can a person with no immediate intention of visiting a hotel sue the establishment for not providing disability access details on its website? This question has been at the forefront of a recent case, and the U.S. Supreme Court has just brought down the gavel on this intriguing matter. The case in question was initiated by a visually impaired woman named Deborah Laufer against a hotel in Maine. She claimed that the hotel violated a federal rule under the Americans with Disabilities Act, or the ADA. This rule mandates that reservation systems must include accessibility information. Laufer, who self-identifies as a tester of hotel compliance with the ADA, argued that the omission of such details was a clear violation of the Act. However, this case was not as straightforward as it might seem. Laufer, after filing this lawsuit, dropped it along with others she had initiated. This action was taken after one of her attorneys was disciplined for ethics violations. Interestingly, the hotel in question modified its website to include accessibility information after the lawsuit was filed. The Supreme Court, after examining the case, unanimously determined that it was moot and dismissed it. The decision highlights an ongoing debate among lower courts about the standing in such cases. In simpler terms, who has the right to sue? The crux of the issue lies in the role of testers, individuals who assess the accessibility of establishments and file lawsuits on behalf of people with disabilities. The question is whether these testers have the right to sue if they do not intend to visit the establishments themselves. Civil rights groups have voiced concerns that a ruling in favor of the establishments could limit the use of testers in identifying discrimination. This recent Supreme Court decision may have far-reaching implications on the ability of people with disabilities to access necessary accommodations. It also raises questions about the role of testers in advocating for necessary accommodations for people with disabilities. In summary, the Supreme Court's decision to dismiss the lawsuit brought by Deborah Laufer against a Maine hotel has shed light on the complex and nuanced issue of disability rights and the role of testers. The court's decision also underlines the ongoing debate on who has the right to sue in such cases, a matter that will undoubtedly continue to be a topic of discussion in the legal world. Despite the dismissal of this case, the conversation on accessibility and disability rights is far from over.